the panelists would like to have any insight from you about any recent judgments on the IT Act of the Supreme Court, or how the courts are dealing with these electronic contracts.
See, I had sketched out the area where we have dealt with the validity of the contracts. Now, what has to be understood is that whether it's an inked contract or a contract through eContracts, the principles of contract are no different. The Contract Act is the same which applies. So there's no difference. In fact, in the morning only saw just now some questions which are supposed to have been received by you. It's a presumption as if the e-contract is some other creature. That's not there. It is a contract. The only purpose of the e-contract is to facilitate without possibly the personal presence of the parties, and to have a quicker entering into the contract and storing it in a particular manner. Therefore, the precautions which have to be taken are what are provided in the IT Act and the amendments to the Contract Act, which is the execution itself. So like any inked contract, suppose somebody would try to raise a plea of this is not my signature or this is a fraud. So same principles apply here. So in fact, the greater authentication to signature aspect makes the enforceability of the contract a greater certainty. So it's not a different creature. That's why I said this impression has to be dispelled as if some different regimes apply to a e-contract, which is a different creature itself. In my view, it is not so. It's like any other contract, same principles apply, same things apply. The precautions are only in execution of it.